we have is discovery in these cases. And too broad a topic to get into much detail here. I think the main thing is that the discovery is pretty intense. You have to really dig into these cases and find out the other similar incidents, the other accidents. You have to fight for it. Manufacturers will not give you a hot document or a good document without getting an order for it to be produced. So they'll file an objection, and you must pursue the manufacturer. You must go to court, compel it. It's a lot of work, tremendous amount of work.
What I'll say about discovery is being involved as lead trial counsel on one of these cases. I've actually been involved with a few. I just haven't had a chance to try one. The auto manufacturers don't want to try one of these cases against me. They've settled. I have found that I don't know what the heck I am doing when it comes to discovery. So AIEG, you guys, you're who I pick up the phone and call. What do I do? I got these discovery responses. How do I respond? What's out there? And if you're not part of this organization or calling the right people, you're going to be completely lost, and you're not going to have what you need to go to trial. Because discovery in these cases, it's a whole different universe. It really is. And would it be fair to say that they hide things and that they lie?
Oh, you wouldn't think, would you? The most important takeaway today should be, if you're in one of these cases, you have to network. You have to look to people who have done these. That means AIEG and the 900 plus members in AIEG. And the other thing is sharing protective orders. And to use an example, I will show you a provision here. Sharing protective orders are long and they're boring. And you know what? It's easy to just give in and agree to non-sharing, because then they say, oh, I'll give you all these documents. You just have to agree not to share them. Don't fall for that. Don't do it. The whole concept of AIEG is sharing. Do not agree to a non-sharing protective order. And so I had a case quite a while ago against Ford involving a fuel system defect. And they had this collection of documents in their fuel system library called the Harrigan documents. I won't bore you with it, but they had super confidentiality on them, a super protective order, so to speak. No offer case. I took that case to trial. I was able to get the Harrigan documents in, and part of what I was able to get out of that was sharing. This is what I tell our lawyers to try to get in all cases, to share with any attorneys investigating a case, any attorneys who are prosecuting a case. There's different levels of sharing, but this should be what we strive for. Should be the type of sharing that we want. And if anybody wants examples of sharing protective orders, we have them. Contact Dan, contact me, contact any AIEG lawyer. But the takeaway should be, do not agree to non-sharing protective orders. It will hurt our profession. It will hurt our clients.